welcome back to the One Take Show podcast. In this episode, we are in conversation with Mr. Vyapak Desai. And for anyone who's even remotely interested in law or is related to the legal fraternity, already knows everything about Sir. But nonetheless, Sir heads the international disputes and investigation practice at Nishith Desai Associates. And in this episode, we talk about Arbitration Act, the goods and the bads of the same. Throughout the time, we have seen Arbitration Act facing various amendments, going through various changes, and all of these changes have created a positive and a negative impact of the same, and how the experts in the field accept it, implement it, and bring it to the practice is something that we derive out of this conversation. And like all the viewers who are going to watch this conversation, I too am very grateful to have this opportunity to learn all of this directly from Mr. Vyapak Desai. So I'm really excited about this episode, and I'm sure that you're going to love it as well, which if you do, please make sure you like, share and subscribe to the channel. If you have any suggestions or feedbacks, write them down in the comment section. I would love to read them. And without any further ado, let's jump right in. Hello, sir. Welcome to the One Take Show. It is truly an honor for me to have this opportunity. I truly cannot believe that I have this opportunity to speak with you and to learn from your valuable experience. Thank you so much for awarding me this opportunity and sitting down with me for this conversation.
Thank you. Thanks a lot, Kostu. And I have seen some of your work in the past, so it's a privilege for me as well. So thanks a lot for the invitation.
Thank you so much, sir. That means the world to me. And I think this is one of the most special conversations that I ever had, because primarily I have an opportunity to learn about one of my favorite subject areas, arbitration. And that too from someone who has such a wide, rich, and extensive experience. So before we begin with the conversation, which essentially is analyzing how Arbitration Act has evolved and what are the goods and the bads in the Arbitration Act from four various perspectives, what are those major conceptual reasons why we are having this conversation? And then maybe we can move towards the first issue at hand, that is Section 29A.
So I think broadly speaking, arbitration as a law, right, has evolved over a period of several decades now. We formalized arbitration through a 1940 Act, and had various other legislations in support of that law till about 1996, when we adopted, and we were very early adopters of unilateral model on arbitration law in 1996. And then obviously, since then we have seen a huge amount of interest in alternate dispute resolution and arbitration. So I think while India has in a way accepted this form of dispute resolution for several decades now, but still we have not made our mark in terms of the field, and we have not been able to utilize this mode of dispute resolution fully. So I feel that's where since I started practice, I have been hearing about how good this dispute resolution mechanism is, and still we are struggling in a bit to put the right perspective to this dispute resolution, which can, it's not only about the dispute resolution that it accords. It is actually part of a larger commercial economy and the way it supports the businesses rather than traditional litigation way. So I think, in my view, this is the most critical and important part of a business story, and everyone needs to have a certain kind of certainties when they do business, because unless that is there, taking business risk is okay, but nobody wants to take a litigation risk, right? So that is where arbitration comes in, and I'm sure in next few years this will become the most successful mode of dispute resolution for Indian businesses.
Right, absolutely, sir. And I think it is the certainty that comes with dispute resolution that makes it so attractive, especially for the commercial disputes and the commercial entities adopting for it. And so there is
Sure.
something you mentioned that there is a need for a proper perspective application of this act, and that is something that we need to still improve on. For as a mode of introduction for our audience as to what are those four major themes that we are discussing, what are those major issues that you would like to highlight?
See, I think very simply put, there are four stages of an arbitration, right? The first stage is uh, pre-invocation of arbitration. In sense, when the dispute is just brewing, the commercial business acumen is still underway. People are trying to resolve the points, but you need certain clarification, certain interim injunctions, certain status quo kind of a situation. So you are at a stage where arbitration has just not started. I think there are a few things which one needs to take into account as to what kind of reliefs you can get prior to arbitration, whether you can do mediation, whether you can go to court for interim reliefs, whether you can invoke emergency arbitrations and stuff like that. So that is one area which requires an attention, which is pre-invocation of arbitration. Second is your process of invoking arbitration and setting out the process, where you have a gamut of issues, including appointment of arbitrators, the independence and impartiality, the process of appointing arbitrator, who to go to, whether it is an ad hoc or it's an institutional arbitration, whether to go to court if the other side is not agreeing, and who can be the best arbitrator to adjudicate the dispute. So that is, I would put it as a second bucket. The third bucket is the process of arbitration itself, right? How much time it would take for pleadings and cross examinations, and the process of arbitration, and what you go through as process of arbitration, what rules would apply if you are not going through an institution. Then there are other challenges in terms of going through the arbitration, right, and reaching to the stage of getting the award. So that's the third bucket. And the fourth bucket is, you do all of this to enforce ultimately, right? You want something to get out of it. While traditionally, in most of the jurisdictions outside India, uh, possibly some statistics would say 80 to 90% of the awards are self enforced, in sense people generally don't challenge, or you don't have to really work hard to enforce an award. There are only 10, 15, 20% of the awards which actually go for challenges, and that too hardly 5% of it are successful in those challenges. So I think the fourth and the most crucial part is the fruits of the arbitration, right? As to how do you enforce it, how do you challenge it, how do you execute and get the money or whatever the award says. So I think these are the four buckets in my view, and on each level there are challenges when it comes to Indian process, and we all are improving. I think there is a lot which has happened in last 10 years, and which I don't think happened in last 50 years, right? So we have done a lot when it comes to this law. This law has been amended thrice in last 5 years, and that shows the importance that government is also giving to this law. In fact, one of the major reasons for getting a better ratings on doing business in India index, and the index on contract enforcement, the major factor for that was the changes in the arbitration law and introduction of commercial courts. So I think, as I said, this is not about just dispute resolution at the end of the game. This actually puts India in the forefront straight up when you talk about foreign investments or doing business in India or otherwise. So it is that much more critical than what people feel, that this is just a additional last leg of the total business that you talk about. It is very much in the center of any business decision.
Right, absolutely. And this progress has been quite very stellar, as you pointed out, sir. Quite wonderfully explained how this entire process is so significant for the business environment in India and how it is functioning. Dispute resolution through arbitration has become a very staple go-to and has become a very popular subject also, as from a perspective of a law student. Everyone is so very passionate about arbitration because it provides us so many opportunities. But one very distinguishing factor that arbitration has, that helps arbitration stand apart from litigation, is the effective timeline and how it is supposed to be very quick, it is supposed to be concise, it is supposed to be in a definite period of time. And with those timelines, as you suggested, there are various amendments made, and one of those amendments being Section 29A. Now, at this stage, I think I would request your comments on Section 29A as to what you interpret out of that amendment.
Sure. So I think there is a huge amount of history alongside this Section 29A, but let me try and put it as as succinct as possible. I think again, traditionally outside India, the usual mode of dispute resolution, particularly in arbitration, takes about, let's say, 18 to 24 months. This is something which is generally accepted principle, that if you start a dispute, whether it is in courts, whether it is in arbitration, typically if it takes, and I'm talking about a sufficiently large complex dispute, I'm not talking about something which can be done in 6 months and things like that, but I'm saying on an average, all institutions and everyone accepts a general norm that it can take about 18 to 24 months. When it comes to India, as we know, we have been traditionally known as a never-ending situation when it comes to dispute resolution. We have almost 30 million cases pending in Indian courts, languishing for 40, 50 years, some of the cases. And if you ask a lawyer how much time it can take for even a suit in an Indian court, or sometimes even an arbitration, typically, statistically, people will say it can take anywhere between 10 years to 15 years to sometimes 20 years. Now, this is completely unacceptable. The joke around India is because we believe in reincarnation, we don't even finish our disputes during our lifetime. We come back to do our disputes. So
Wow.
I think that was the situation even after introduction of Arbitration Act of 1996, which is supposed to be providing efficient, effective, and quick, definitive resolution process. So I think what India did well in 2015 was to introduce this section called 29A, which brought in a very strict timeline, and we are the first country possibly to bring a statutory timeline to an arbitration, and which was very well accepted in a way. There were some criticisms as well, that how can you finish an arbitration in 12 to 18 months, because 29A originally said that all the arbitrations are to be completed within 12 months, maximum extended to 18 months, and that to subject to consent of the parties. So there was some criticism that this is not achievable in many complex infrastructure construction arbitrations or other complex issues. But I think by and large, since 2015 till to about 2018, experience of the arbitrations practitioners was very, very good. The law was working well. There was a certain amount of discipline and change of mindset, which was really required. It was not about the rule. It was not about the procedure, right? It was about the mindset. Somebody tells me it takes. I stay in Bombay, so if someone says it takes 2 hours from going from Andheri airport to Nariman Point, and then somebody says, okay, I have a metro which will take you within 30 minutes, right? It's not about the process. It's about the mindset. Is there a way to finish your task faster? And once you say that, okay, I want to do it in 12 to 18 months, you will always find a way to finish it, right? The mindset will change, the culture will change. And that's what at least I personally feel happened. And a large part of disputes were getting completed, if not in 18 months, maybe one more extension with the court's approval, but we were finishing arbitrations faster than earlier, and average time of
Mhm.
arbitration was coming down. But what happened, and this is where I have, uh, if I may say, criticism for the 2019 amendment in 20 for 29A. I think we approached the problem completely, uh, I would say, uh, which is not achieving the objective. I think everyone said that we need some flexibility around, sophisticated arbitrations which are run by institutions. So I think what happened in 2019 was when High Power Committee for Institutionalizing Arbitration was set up, and the amendments came in 2019. I think we sliced the cake, if I may say, in a little different way than what we should have done. I think what we did was we removed international commercial arbitrations from the timeline, and and have enforced only timeline for domestic arbitrations. That too, we extended it by saying that first 6 months would be pleadings and then 18 months for the completion of arbitration. So we did, in again, this is my personal view, but we did two major mistakes. I think we should have sliced the cake by saying institutional arbitrations, there will be no timeline, and ad hoc arbitrations, there will be timeline. Instead of saying international commercial arbitrations, there is no timeline, and domestic arbitration, there is a timeline. Because even if it is an international commercial arbitration, but seated in India and ad hoc, we still need timelines. Even if it is a domestic arbitration but institutional, right? We can leave it to the process there. So I don't think we need to, separate domestic versus international commercial arbitration. What 2019 High Powered Committee was set out for was to progress the institutionalization of arbitration. And therefore, we should have done in a way that we say that timelines will apply for ad hoc and not for institution. So this was first major mistake. The second mistake, in my view, is even for domestic arbitrations or ad hoc arbitrations, so long as if you wanted 6 months more, simply say arbitration to be completed within 24 months. But if uh, now to say that the first 6 months will be for pleadings and then the timelines will start, and there will be 100 applications to say when pleadings got completed, not completed. There is, like, crazy amount of literature on when pleadings are considered to be completed. And somebody makes an amendment and this and that. So I think we have complicated it to the extent not necessary. But in all, I think the objective and the intention is correct. Uh, we in India need a proper change in mindset, culture, and discipline on arbitration. And bringing in timeline is not to be seen as a stick, applied by the government or statutory timelines. It has to be seen that this is required to change the discipline, culture, and mindset of arbitration. So people approach things differently rather than look at it as an unending process.
Perfect, right, sir. And this is very important because the moment we start reading into the institutionalization of the arbitration and how the government has been pushing for the fact that India should be a very popular seat for arbitration for more and more companies, we see these are the issues that apply here. I just have a very small follow-up question, sir, just for that bit of a clarification. When you say that the division of the timeline or the classification of the timeline to be more appropriate should be on the basis of institutionalization and ad hoc arbitrations, and it is not so in the present case, what are the practical repercussions of this that the practitioners have then to deal with?
Yeah, so the basic practical repercussions are that now even for international commercial arbitrations, which are seated in India, there are no timelines, right? So today, if while drafting a contract, right, if someone asks me that should we choose India as a seat, right? Earlier, at least between 2015 and 2019, I used to say that yes, it's a good idea because at least you have certainty. You need to finish your arbitration within 12 to 18 months, or maybe a little bit of an extension subject to approval from court. But there was a positive enforcement of finishing things in time. Today, it's an unending story. Yes, people can finish it in 12 months, 18 months, 24 months, 36 months, but it is now not subject to any oversight. So this is, in my view, for a claimant, it's a great thing for a respondent. So there is always a second side of the story. But for a claimant, this is, in my view, a little bit of a deterrent because earlier at least there was an expectation that things will get faster.
Right. Perfect, sir. And with the story of amendments and their impact on the legislation as we continue, we see even the latest amendments that have come out in 2021. The ordinance has sort of created another dialogue, debate online when we see in the legal circle about the challenges or the grounds for challenge to the enforcement of the awards, and how those challenges are dividing the lines. They are creating voices on both the ends. Some are in support, some are pointing out the fallacies. At this stage, at this juncture, what would your comments be and your analysis be?
Yeah, so I think if I may say, we are a country, and I always say that we need as little or as less legislations as possible. I think the more we amend, the more we legislate, the more problems we create for ourselves, right? I think because we are so diverse, because there are so many different expectations and different views, I think some of the legislations which are generally okay should be left to itself rather than get amended so often. To be fair and to be honest, I don't think we required the 2021 amendment. The law was good enough to cover even those situations which they tried to cover as part of 2021 amendment, and then it has unnecessarily created a negative sentiment. It was, even without those amendments, in my view, those situations would have been very well addressed by a court of law in a given case. But what has happened, to be very frank, in India and particularly to the arbitration law, I think today, again, we are so uniquely placed country. Uh, we have possibly, I don't know how many sets of law applicable to just arbitration. Okay, we had 1996 Act, which was interpreted very differently in 2002 and 2008 through the judgments called Bhatia International, people may know, and Venture Global. It interpreted that Part 1 is applicable to even foreign seated arbitrations, right? So there is that one law which is in a way applicable to many situations even today. I don't want to go into details, but there can be pending arbitrations where that provision of law or that jurisprudence still apply. Second, we got 2012 Balco judgment, which said Bhatia International and Venture Global are not good law, but that law will continue forever, and only arbitrations which are started after September 2012, 6 September, if I'm not wrong, Balco will be applicable then. Then we had 2015 amendments, which even in a way overruled Balco in certain aspects, because Balco said that if for a foreign seated arbitration you want Section 9, you can't go to Indian courts for interim reliefs. 2015 amendment said no, you can still go for interim reliefs under Section 9. And then it brought in Section 29 for timelines, and it brought in very, very positive amendments with regard to enforcement. So there is the third stage is 2015 amendments. So there is another set of arbitrations which are governed between 2012 and 2015. Then we had this huge amount of confusion as to what kind of arbitrations 2015 amendment is applicable. Is it prospective or is it retrospective? Then we had BCCI judgment which says no, it is otherwise prospective, but for court proceedings, it can be also applicable to arbitrations which started before 2015. So, by the time BCCI judgment came in 2017 or 18, or maybe late 18, I don't remember the date. 2019 amendment came in, and in spite of what BCCI judgment said, that please consider this before saying whether it is retrospective or prospective, the amendment actually did not give any credence to BCCI judgment and said this is purely prospective. So there is another set of law now applicable so far as prospective applicability of 2015 amendments are concerned. And then we again had a judgment in Hindustan Construction, which said, at least so far as Section 36 is concerned, there was never a case of automatic stay when Section 34 is pending, and therefore, to that extent, 2015 law is even retrospective, right? And it is a procedural law. And then we are still struggling with 2019, and now we have 2021. So you can imagine, right? There are arbitrations today running on different set of laws, depending upon your date of contract, depending upon your date of invocation of arbitration, depending upon the stage of arbitration, whether it has reached court, whether you are at the interim stage, and so on and so forth. So there is, utter confusion when it comes to some of these procedural aspects. And frankly speaking, the arbitration law, in a way, right, should be the easiest to navigate because it is largely procedural. What substantive issues are purely issues on merit. But what happens in India is today, 60-70% of the time is spent on interpretation of the Arbitration Act rather than the interpretation of the merits of the case. I think slowly things are getting better. Honorable Supreme Court is clearing a lot of confusion, and thanks to other high courts and other even lower judiciary, I think we are clearing a lot of this confusion as we speak. But still, in my view, some of these things are to be made clearer rather than constant amendments to the act, and let this happen through the practical experiences and jurisprudence, because a lot of these things will get sorted in its own way as things progresses rather than changing all of this, right? So I think that's my take on all the amendments and what's happening with the law since 1996.
Right, fascinating. I think first of all, I need to go through this particular section of the conversation at least twice to completely understand the creation and the various layers of understanding that is required to completely decipher how the arbitration and various arbitrations are actually functioning on different acts at the same time based on their contracts or based on the cause of action and whatnot. Absolutely wonderful, sir. And I think as a follow-up, I think is also one of the third major challenges that we've discussed is how the 2015 amendment by the creation of the amendments to Section 9 and has impacted with respect to the urgent interim measures that were to be awarded for the creation of emergency arbitration and how it is impacted. So I know you have previously spoken about emergency arbitration in one of your webinars, and I was fortunate enough to attend that. But quite briefly, if you could please tell us what could be the impact on the emergency arbitration at this stage.
Sure. So there are three different parts to this. One is your Section 9. Okay. Just to clarify, originally till Balco came in 2012, the law as interpreted, I would not say law as it stood, but law as interpreted was that Section 9 is applicable even for foreign seated arbitrations. And you can come to Indian courts even if your arbitration was seated in Singapore, even before the arbitration is invoked. Then came Balco, which said no, if it is foreign seated arbitration, Section 9 is not applicable. Then came your 2015 amendments. Three things happened in 2015 amendments. As I said, the first one was Section 9. Section 9 was then made applicable to all arbitrations, including foreign seated arbitrations, unless parties agree otherwise. Which means that before invocation of arbitration, during or after, if you need certain reliefs which cannot be granted by the tribunal, right, then you can go to court in support of arbitrations for getting that interim reliefs. Second thing which happened in those amendments is Section 17, which allows you to go to the tribunal itself for getting interim reliefs. And that was very narrowly interpreted before 2015. What 2015 amendments did, that it made Section 17 akin to Section 9, which means whatever court can give, tribunal can give. But that is only after tribunal is constituted, right? So one is before tribunal is constituted, you have no option but to go to court. After tribunal is constituted, you go to the tribunal and take similar reliefs. I think there is a third aspect to this, which is internationally accepted, which is the emergency arbitrations, where let's say your contract says appoint 3 arbitrators. It will take 30, 60, 90 days to appoint 3 arbitrators, right? Till that time, what you do? Either you go to court and all the issues related to confidentiality and other things are compromised, and you are taking arbitration to court, which in the first place you didn't wanted to go to court and therefore you chose arbitration, right? So I think what internationally is done is you can go to the institution under whose rules you are doing the arbitration and get an emergency arbitrator appointed. The Law Commission report, based on which 2015 amendments came, also suggested to introduce emergency arbitrator appointments and recognize emergency arbitrator, which was not accepted by the legislation. So we don't have emergency arbitrators so far as legislature is concerned. But through 2015 till about 2021, many cases where emergency arbitrators are appointed in other institutional rules, India has taken a very positive approach, including in the recent Future versus Amazon case, where emergency arbitrator award was considered and enforced positively so far as an India seated arbitration is concerned. Though it was under Singapore International Arbitration, SEAC rules, but still it was a Delhi seated arbitration, and emergency arbitrator provisions, though not part of the law, were upheld. So I think that's the gamut, that's the extent of interim relief provisions so far as arbitration is concerned. And if I may say that these are the provisions which actually make arbitration as a parallel dispute resolution rather than an alternate dispute resolution, right? Because now you don't have to go to court till you have to challenge or execute the award. At every stage, the full dispute resolution can happen under the provisions of the arbitration law, rather than going back and forth to court for, let's say, appointment of arbitrator or interim relief or some other court intervention or appeals and so on and so forth. Now institutions can appoint arbitrators. You can appoint an emergency arbitrator, so you don't need Section 9. Section 17 is good enough even after the tribunal is appointed, and 17 has orders can be enforced as an order of the court. So I think there is a lot which has happened to make arbitration as a parallel dispute resolution rather than an alternate dispute resolution.
Right, sir. Arbitration becoming the parallel dispute resolution is perhaps the tagline takeaway of this episode, which I will particularly use. Sure. It's very fascinating. It's very fascinating, sir. And since you talk about appointment of the arbitrators, and you mentioned that now various developments are evolving as to how appointment of the arbitrators is to go through properly, and there is an application of IBA guidelines, which I think it becomes extremely relevant here. And for that purposes, what are your views on the
So
acceptability and
again,
applicability of IBA guidelines? Yes, sir, please.
sure. So I think again, we had a lot of issues in the process of appointment of arbitrators as well. The At least as we know, government is 60-70% of the disputes are with government bodies or government linked bodies. And one of the methods of appointment of arbitrator was that government used to put a clause that their own general manager or their own uh, engineer or somebody would be appointed as an arbitrator, or there were sole discretion to appoint of arbitrator was to the claimants and things like that. I think that created an issue of bias and prejudice and conflict of interest and so on and so forth. I think again we are the first adopter of IBA guidelines under a statute, which is just a guidelines as it means by saying it is a guideline, but we enforced it as a statute, and we brought the red, orange, and green list for the purpose of conflict of interest. So I think that was a major step to avoid any kind of bias, prejudice, or conflict of interest, which is possibly the only ground on which award can be challenged. So we eliminated that part. So we achieved many more objectives by bringing in that provision. Second, I think the jurisprudence is very clear now that you cannot appoint your own person as an arbitrator. And third, I think the pending amendments of 2019 amendment, which gives powers to the institution for appointment of arbitrator rather than running to courts. I think that is still pending enforcement, or rather pending, application. But once that happens, I think most of the issues in this regard will be, taken care of.
Right. Perfect, sir. I think this is perhaps the most comprehensive conversation I've had on arbitration. I won't take much of your time. I understand that you've had to particularly take time off your really busy schedule to sit down with me for this conversation. As we close this conversation, sir, your conceptual overall views on what is the status quo, and how can the young practitioners who are possibly going to either try and enter into arbitration and learn more and more from your experience, what is your current take in the status quo situation?
So I think maybe 20 years back, not very old in that sense, when I started, law as a profession, I think only thing we heard was a lot of negative, feedback when it came to generally dispute resolution and particularly arbitration, because people said that it is all ad hoc. The arbitrators don't take it seriously. The councils don't take it seriously. Parties never get what is required as an effective, efficient resolution process. And we don't have institutions. We don't have law. And nothing was working out well. But I think in last 10, 12 years, there is a sea change. As I said, this has now become a go-to process for dispute resolution. And why I'm saying it's a parallel dispute resolution, because again it's a mindset issue, right? The moment you say alternate, it is given a second status, right? It's like a second class citizen, right? But if you say parallel, I think suddenly the mindset and culture changes. But I think if I may summarize the problems, right, outside what we discussed on the law, is one, we didn't had good institutions to run the arbitrations. Okay, we didn't had, I would say we had law, but it was not rightly interpreted or implemented, and therefore we need amendments. And third, we needed good environment and overall infrastructure, right, to run an arbitration, in sense the ecosystem, right? I think, and which requires the support of judiciary and everything. So all the three aspects, in my view, are in the right place today, right? We have institutions like MCIA in Mumbai, Delhi Institute, International Arbitration Center. You have NPAC in Chennai and many more other institutions. And the law is going towards institutionalization of arbitrations. So that problem is in a way taken care of. Second, we had good amount of jurisprudence and good amount of amendments to take care of the law. So we are already, taking care of that problem. And third, in terms of ecosystem, there again, I think you need two sets of people, or rather three sets of people to take this seriously. One is the arbitrator community, right? Because your arbitration is as good as your arbitrator. Now, the pool of arbitrators are increasing. It is no longer just retired judges or just some lawyers or something like that. I think we have a very good pool of very good retired judges, very good counsels, very good engineers, very good chartered accountants who are ready to become arbitrators. So I think we have good pool of arbitrators and willing arbitrators to work on it. Second is your judiciary. So we have very good sitting judges who are supporting arbitration. And the third is counsels. We have now things like Indian Arbitration Forum and others where lawyers are coming together to create an arbitration bar and things like that. So I think on all three aspects as an ecosystem, right? This is becoming a serious business rather than, or a serious profession, if I may use the right word, rather than something which was considered as a second class dispute resolution method, right? So I think on all three counts, things are improving. If somebody doesn't want to go to courts every day because there are other challenges in terms of courts, but somebody wants to still enjoy the aspect of dispute resolution, right? The arguments, making some difference to the whole issue. Corporate law is obviously one area of practice. IP law is one area of practice, but arbitration has given that option where you are able to do things which necessarily you may not be able to do through other areas of law. So I think, in my view, it has a great future. We have just started, and as I said, there are 30 million cases pending in Indian courts. Just imagine even a fraction of those coming to arbitrations, and what kind of support we'll need from legal community for that. So I think this is a very, very fascinating area. And if you focus and remain little disciplined, there is huge opportunity as far as, and to my mind, it is also very satisfying, right? Because you are making a difference by providing a dispute resolution or an adjudication to a dispute, which can make a big difference in the life of a corporate or a life of a party. And so you are also in a way contributing to something which was stuck for many, many years. So I think it's a overall a great area of practice, and I would encourage students, not because of any glamour part of it or any any other issues, but I think purely because of the nature of the work and the satisfaction you get through it.
Wonderful, sir. Thank you so much for this conversation. And I truly, I can't believe I have this real opportunity to have had this conversation and to take this out for all the viewers. Before we wrap this up, sir, do you have any closing remarks for our viewers?
No, I think we have discussed a lot. I think no major closing remarks, but be safe. This is the time to remain safe so far as COVID-19 is concerned. And again, arbitration has been a great alternate, or I would say great support to dispute resolution even in these times, because it was very easy to adopt virtual hearings and stuff like that in arbitration. The courts also did a great job, but arbitration was easier, right? So, and we are looking at online arbitrations, and there's huge amount of innovations happening there. So watch out this, this space for many more things to come, because there is lot of autonomy and lot of innovation coming your way.
Right, perfect. Thank you so much, sir. Thank you so much for this conversation,
Thank you.
and thank you so much for your time.